We have a quorum, and it is the appointed time. Let me call the meeting to order. First item on the agenda, confirmation of minutes of meeting and matters arising. The minutes of the last meeting have been sent to members via CB bracket 1697/14 to 15. The clerk has not received any proposals for amendments. If members have no particular views, can we confirm the minutes, please? Okay, no particular views. Okay, minutes confirmed. Item 2, information papers issued since the last meeting. After the last meeting, we have received 3 papers, and the details are in the agenda. Date of the next meeting and items for discussion. On the 4th of May, we are going to have our next regular meeting, and 3 items have been proposed. Number 1, briefing on the work of the Hong Kong MA, and then annual briefing on the work of the Financial Reporting Council, and number 3, Deposit Protection Scheme Amendment Bill 2015. Members, would you agree to having these 3 items for the next meeting? No particular views? Okay. I would propose that we advance the meeting to 9:30 in the morning, so we will have enough time to take care of all 3 items. I think you will support that. Okay, next. Item 4. Legislative proposals to allow the SFC to provide supervisory assistance to regulators outside Hong Kong. Can we invite the administration team to come in now?
I'd
like to welcome the representatives of the administration and the SFC. First of all, I'd like to invite Ms. Joyce Ho, PAS for Financial Services and the Treasury, to take us through the paper. Thank you, Chairman. Together with the SFC, we are here at the panel to brief members on the amendments to the SFC so that the Commission can provide supervisory assistance to regulators outside Hong Kong and revise certain provisions in the SFO. The main purpose is to allow the SFC to discuss more supervisory MOUs or assistance MOUs so that there would be better regulation on the financial systems, because international cooperation is built on mutual trust, mutual assistance, and reciprocity. It is important for the SFC to be given the same kind of regime of other international bodies. According to Section 180 of the SFO, the SFC can get certain information for its own supervisory matters. However, under the present ordinance, it is not sure, and it is actually not given the power that it can provide assistance to overseas regulators in order to get information to assist those regulators. Therefore, we think we should revise the SFO so that the SFC would be empowered to provide supervisory assistance to regulators outside Hong Kong. In making the legislative proposal, we are particularly aware that in order that we provide enforcement assistance, we don't want to get excessive information and disclosing information without adequate safeguards. We'd like to strike a balance between providing supervisory assistance to a regulator outside Hong Kong in return for its assistance and not giving excessive information. So we will only provide assistance in a limited way, and this means that the request must be for the purpose of the licensed operation, which is regulated by the SFC and the regulator outside Hong Kong, and whether there will be risks caused to the financial stability of the jurisdiction of that regulator. And also, the related corporation of a corporation licensed by the SFC must be regulated by the regulator outside Hong Kong. And also, we have to provide assistance only when the public interest is met. Say, for example, whether the requesting party is able to and willing to provide reciprocal assistance when it is requested by Hong Kong. And number 3, apart from existing legal safeguards, we'd like to further stipulate that regulators outside Hong Kong must provide a written undertaking to confirm that the information obtained from the SFC because of the request for assistance will solely be for ascertaining the matters described in the request. And number 4, the information provided by the SFC will only be limited to the regulated activities under the SFC. And in December 2014, we conducted public consultation and the industry generally supported the proposal. At the same time, we'd like to refine certain provisions in the SFO to reflect the change of circumstances since the SFO was enacted in 2003. And the provisions that are to be refined are in the paper. Maybe I pause here. Chairman, 3 members, Mr. Dennis Kwok, Mr. Kenneth Chan and Mr. Kenneth Leung, and also 2 other members would like to ask questions. Mr. Dennis Kwok. Chairman, can I be given more time because there are not many members? Well, in fact, there are many in the room. If you like, you can have a second round. I can see that you have received a total of 8 written submissions during the consultation period. I understand the legal sector has commented on the issue. We said and asked, actually, when this is implemented, will you consider legal professional privilege and also privilege against self-incrimination? And I'm talking about information and papers about these. Will they be handled in a special way? My own worry is whether the SFC will seek information or regulators outside Hong Kong. In fact, do they really need the information, and whether they can get the same information from other channels and sources, and whether they have done their best, that is the SFC, whether it will do its best in order to ask as the SFC why the other party would like to have the information and why their investigation will be assisted. And also, if the other party has given an undertaking but then it contravenes the undertaking, what kind of action can the SFC take as a result? I think all that has to be written down. My own concern is also about the mainland regulators. They may come to you for information and documents. They may ask for assistance from you. What kinds of safeguards will there be in order to protect the basic rights of businesses in Hong Kong? Because the mainland have a very different legal system. Say, for example, the mainland does not exactly accept the concept of legal professional privilege. So how are you going to deal with such differences between Hong Kong and the mainland? I hope you will be aware of these points, and when you make the actual provisions, please think clearly how you want to deal with those. Ms. Joyce Ho. Who will take the questions? Mr. Andrew Young.
The honourable members raised a number of issues on legal professional privilege. We're well aware of that. I mean, that's a fundamental human right. I mean, it's also protected explicitly in Section 380, subsection 4 of the SFO. So nothing that we could do can override that. So if someone, if documents are covered by LPP, then we would not obtain them, and we would not be able to obtain them or require them, and that applies to enforcement cooperation currently. That's the LPP point. In terms of privilege against self-incrimination, there is already protection in Section 186, subsection 6 of the SFO, and supervisory cooperation is not intended to produce information that's to be used in proceedings, and there would be an explicit undertaking by the overseas regulator not to use information in that way. However, in the event that information was disclosed that subsequently the overseas regulator did want to use in enforcement proceedings, it would then need to come back to us and initiate initiating the process for investigatory cooperation, and then that would pick up the existing protection against for the privilege against self-incrimination. So it would follow that route. So that's made explicit in the draft provision that we are formulating currently.
And how about also the extra confirmation that you'll be seeking from the overseas regulators as to whether they really need the information, that they cannot get it from another source, and why is it that they need this information to assist with their investigation?
Yes, we've heard those points from the submissions, and we've there is language suggested that the overseas regulator would make a statement to the effect that it's not able to obtain the information by any other reasonable means. So it would have to assert that. And also, in terms of, I mean, each request would set out why they wanted it. And because we would be making similar requests ourselves, we would be able to evaluate whether or not that was a reasonable or a sensible request in a supervisory context. So there'll be a right, and it'll be discretionary anyway. So, I mean, we won't have to comply. I mean, it's not a demand.
Mr. Kenneth Leung, thank you, Chairman. There will be some changes to the SFO so that the SFC can provide supervisory assistance to regulators outside Hong Kong and exchange information with them. My first question is it that you have signed an MOU, or will you sign a protocol with overseas regulators before you do it? The law will give you the power, but will you sign such protocols or MOUs with each regulator outside Hong Kong first? Number two, if a regulator outside Hong Kong would like to ask you to get information about a Hong Kong licensed corporation, will you inform the licensed corporation concerned that that is the case? And is there an appeal mechanism so that the licensed corporation can object to the submission of information, saying that it doesn't think that it is appropriate for you to give the information to a regulator outside Hong Kong? 3 questions, please. Who will take those questions? Yes, Mr. Shipton.
Thank you. I thank the honourable member for his question. The first question, the first component part of that question relates to the signing of protocols and MOUs. There are right now in existence a range of different memoranda of understanding and protocols with international regulators, many of which do not actually currently touch upon supervisory aspects. So part of the legislative amendment here is to enable us to be able to enter into these protocols and MOUs with other regulators moving into the future to give effect to the request for information provisions. I will underline and emphasise that there are, in the existing protocols and MOUs that do exist, an ability to provide and exchange information already. This is why this proposal is a modest and incremental step from the existing position. But the legislative amendment will enable us, in effect, to enter into what has become, post-financial crisis, a new global standard of exchange of information under those MOUs, and to enable us to, in effect, enter into this new generation of MOU and protocol arrangements. I will also stress that entering into these protocol arrangements will be on the basis, amongst other things, of reciprocity. And that is something that we will exercise our discretion in. And so we will not be exercising this power unless there are these protocols and MOUs in place. You also ask about the, in effect, I think, the protections and appeals. There isn't an appeal mechanism per se under the power that we have right now, and also the proposed amendment to Section 180. But there are protections. There are protections, and my colleague has just mentioned them in relation to self-incrimination and legal protection. There are also a number of different protections which are proposed in the legislative amendments, which will provide safeguards and limitations as to the provision of information, and will make sure that it is narrowed and contained and restrained to information that is essentially relevant to the compliance of a overseas regulated entity to that overseas regulated regulation and or the financial stability of that overseas regulator.
But there's no appeal procedure for the licensed corporation if they think that the information to be provided is not, relevant or is commercial secret, things like that. No.
There's nothing. There's no direct appeal mechanism. Of course, as you know, there are general principles which I've mentioned that restrain or provide overarching protections, but there isn't an appeal mechanism built into the current provision of Section 180, nor is it proposed to insert that in the amendment.
Mr. Sin Cho Kai, I have a few questions of principle. I'm sure we will revisit these issues when we study the amendments later.
I want to follow up a question raised by Mr. Kenneth Leung. If you are authorized to enter into MOUs with regulators outside Hong Kong, what's your plan on this? Are you going to have bilateral MOUs or multilateral MOUs or both? By bilateral MOU, I mean you enter into an MOU with a specific regulator. It's a one-on-one, one-to-one arrangement. So what's your plan on this? Second, you know that for certain crimes, well, they may be regarded as crimes in our SFO, but not so in other jurisdictions. And sometimes the reverse is true. Some non-compliance might be regarded as a crime, but not in Hong Kong. So when you consider what kind of information can be subject of information exchange, are you going to consider criminality in Hong Kong as the starting point? We'll take this question.
I thank the honourable member for his question. The plan moving forward for bilateral and multilateral MOUs are the following. The practical reality is that we will most likely enter into a number of bilateral MOUs which will, as I mentioned in my earlier remarks, respond to the post-financial crisis next generation of MOU and supervisory cooperation arrangements. If one looks at how MOU arrangements have evolved in the last decade or so in relation to enforcement cooperation, then it is important to note that they have evolved from a position where there was a web of bilateral MOU arrangements to a master MOU arrangement under the auspices of an international body called IOSCO. It is very possible that in the future that the bilateral arrangements that we hope to enter into will evolve in time to a master international consensus type MOU arrangement. So the honourable member is absolutely correct in potentially foreseeing an evolution from bilateral arrangements to multilateral MOU arrangements. In relation to the honourable member's question about criminality, it's important to emphasise that these arrangements do not touch upon, and it is not threshold upon, criminality. The threshold under the proposed amendments relate to compliance with the other jurisdictions' rules relating to compliance of their, in effect, regimes relating to securities regulation and or the financial stability of that jurisdiction. That is the threshold. And in effect, it is a preventative threshold and assists in the other jurisdiction in being able to appropriately supervise their market and satisfy themselves as to the adherence of their securities regulation in that market.
Mr. Christopher Chung, thank you, Chairman. Well, my concern is that the proposed amendments would mean that you are given a wider freedom to release information to overseas regulators, and whether SFC will do it excessively, and that irrelevant information will be released, and whether sufficient safeguards are provided. In paragraph 11 and paragraph 12, it stated that the other regulator will have to give certain undertaking before the information sought is given. What is the current arrangement now in relation to this supervisory cooperation? Are you going to follow the existing practice? Why don't we impose another criteria so that the SFST, Secretary for Financial Services, and the Treasury, or the Financial Secretary will have the final say? This will provide a better safeguard and give people more confidence against leakage of information.
Mr.
Shipton.
I thank the honourable member for his question. He raises very important points in relation to the safeguards that we are aiming to inject into the proposed amendments. It is absolutely important that there be appropriate safeguards and, as the honourable member suggests, avoid excessive utilisation of this provision, because of course it is worth noting that under Section 6 of the Securities and Futures Ordinance, we at the Commission have to be very much mindful of the efficiency and utilisation of resources. There are a number of safeguards that I will quickly also mention, which in effect codify our existing procedures. We have these internal procedures which we are now proposing to codify into legislation, and they include the fact that this proposal is limited and narrow in the respect that it can only relate to requests for assistance in relation to financial stability and compliance with regulation in that other jurisdiction. It can only be in relation to a licensed corporation or a relevant or a related company of that licensed corporation, who is then also licensed in both Hong Kong and in that other jurisdiction. The other regulator needs to have a similar role to us. It needs to also have existing adequacy of secrecy provisions. We also are under an obligation to exercise this power when it's only desirable or expedient to do so, and when it's in the interest of the investing public or the public interest. We will also require a number of written statements from the other regulator to ensure that this information cannot be obtained by any other reasonable means, and it is for the express purpose that of determining adherence to the compliance of that other regulatory regime and or impacts the financial stability of that other regulatory regime, and without that information, these tasks would not be able to be achieved. And then finally, there are a range of different protections that we will expect of the other regulatory regime to write to us in relation to the usage of this information, the protection of confidentiality, the non-disclosure, and very importantly, that it will not be used in any proceedings. This, the honourable member, I hope, will satisfy your concerns about excessive usage and also hopefully give you confidence that there are protections and safeguards already proposed in the amendments.
梁君彥議員。
多謝主席，我諗咁多同事都係好。
Mr. Andrew Leung, I think members here are concerned about how the information is going to be used when you provide information to an outside regulator. You know, we have been watching very closely on how this is done for tax information. That's why we need to proceed with caution here. A member has asked whether there will be an appeal mechanism for the affected licensed corporation. We note that under the tax information arrangement, there is an appeal mechanism, and there's also the final resort of taking the matter to the court. I hope similar provisions can be incorporated here. I hope the government and the SFC can consider that similar provisions be provided to make sure that we have sufficient safeguards. I think the overriding principle is that while we want to have international cooperation in enforcement, it must be very narrowly based and focused. Will the government or the SFC consider my proposal here? Who would take this question? Ms. Ho?
Mr. Ship.
I think Mr. Shipton has already said that basically this is a very restricted scope in terms of information provision, and we have to make sure that safeguards are put in the law. SFC will not be given power to obtain excessive information, and then the information can only be released subject to certain conditions. What about appeals? Yes, we don't have anything in the proposed amendments. Are you going to make reference to similar safeguards in respect of tax information exchange? Or will perhaps refer to the Inland Revenue Ordinance and come back later? Mr. Wong Kwok-hing. My question is a simple one concerning cooperation with regulators outside Hong Kong, and whether it's really reciprocal. Can you repeat the question, please? Well, if we provide regulatory assistance to regulators outside Hong Kong, are we talking about a fully reciprocal arrangement here? Is it fully reciprocal? Mr. Shipton?
I thank the honourable member for his question because he raises a very important point, and that is that it is our intention to provide for reciprocity when we enter into these arrangements that I discussed before about protocols and MOUs. These MOUs and these arrangements will be entered into on the basis of reciprocity. I would also like to emphasise that there is already existing provision under Section 186 that there be consideration as to the reciprocity of the arrangement and request. And then finally, I would also emphasise under Section 6 that the Commission needs to be mindful of the efficient use of resources, and therefore it is in our best interests to only enter into these types of arrangements because we too want to avoid excessive use of this provision to make sure that they are reciprocal. It is also worth emphasising in response to the honourable member's question that Hong Kong is one of the most open markets on earth. It is actually in our best interest to have not just assistance from a committee of regulators and committee of nations perspective, but also to enable us to have similar powers to request an overseas regulator information that will have an impact upon our financial stability and upon adherence to our rules. So the honourable member is absolutely right to raise the question, which is an important one, about the reciprocity of this arrangement, because we very much see these powers as codifying and reinforcing an existing principle that we need information from overseas regulators, and of course we want to adhere to international global standards on being able to facilitate requests from overseas regulators. So very much reciprocal, very much two-way, and very much reinforcing existing legislation, as well as reinforcing and re-enabling that as a matter of practice.
Thank you for your replies. Maybe I can seek some elaboration here. As you have said, you want to codify the arrangements, and that is already the existing arrangement of reciprocity. So I hope it would be put into the explicit provisions in the codification. Mr. Shipton?
Honourable members' comments are taken, and we will look at how the amendments interplay with the current section 186 subsection 4.
好，現在咧就進入第二輪嘅。
All right, we are now in the second round of Q&A. We have 3 members who would like to raise questions. Mr. Kenneth Kwok.
4 minutes.
To follow up on my first round of questions, which is number 1, what if there is a breach of undertaking on the part of the overseas regulators? What sort of actions would the SFC take to pursue or any remedies on behalf of the licensed corporation? Secondly, I'm concerned about the difference of the legal system between the mainland and Hong Kong, and one could imagine that there will be a lot of mutual requests between the 2 jurisdictions, and including the CSRC, etc. So how do you intend to deal with the differences in the 2 jurisdictions, and if the CSRC is to breach its undertakings under certain circumstances, what actions can the SFC take?
Mr. Shipton, please.
I again thank the honourable member for his first question and his follow-up question. The question of, in effect, trying to enforce the regimes, enforce the requirements, this is, in effect, in the realms of international relationships between regulators. It would be a very grave and serious matter if a regulator was to breach the terms of, firstly, the MOU and protocol arrangements that I've previously discussed, and then secondly, breach the additional safeguards and written undertakings that I've also mentioned that will be required under the legislation. It would do a great disservice to that regulator's international reputation, and it will also arm us with grave concern as to future dealings with that other regulator. And of course, we hope, and it should be emphasised, we hope to be entering into MOU arrangements and reciprocity arrangements with a range of different regulators across a range of different jurisdictions. I also want to emphasise, because it's implicit in your question, that we are not dealing here with criminal enforcement. We are dealing with supervisory matters. And the concerns that you raise, there are another set of protections and another set of, let's call it protocols and different sections or different subsections of Section 186 that apply to the exchange of information relating to enforcement actions. Then finally, as my colleague has already mentioned, there are overarching protections against self-incrimination and legal protection privilege, and again, these would be applicable in relation to any request from any regulator with whom we enter into these reciprocal arrangements.
One further example, which is cited in one of the written submissions, is the possibility that a regulator would use the information to pursue other remedies such as derivative actions or class actions in their jurisdiction. So sort of circumventing some of the undertakings that it would have given to the SFC. So in those circumstances, what would you do?
Well, we have proposed that there would not be an ability to use information for any proceedings. And if there was a request or a desire by another regulator to use information for a proceeding, then a separate request would have to be issued by that other regulator, a separate process would apply, and separate protections would therefore be applicable.
And presumably all those will be reflected in the provisions themselves.
We propose to include language that expressly mentions and requires an undertaking from the other regulator that they will not use information for proceedings.
好，梁繼昌議員。
Mr. Kenneth Leung, Chairman. There will be some changes to the SFO, and after that, will the SFC be able to obtain the audit drafts from the mainland more conveniently, especially those relating to state secrets? I like the SFC colleagues to give me a comprehensive update. I understand that there are some cases which are still being heard, but of course, this has something to do with accounting firms practicing in Hong Kong. This has something to do with their basic rights. Who can take the question? Mr. Young?
I mean, that's a much wider issue, of course. I mean, there are a number of cases that are ongoing, and we have regular dialogue with our counterparts north of the boundary. I mean, the matter is in hand. I can't be more explicit at this point.
So will there be more update only after the cases have been decided by the highest court in Hong Kong? Is that your timetable?
Well, we already have a decision in the Ernst & Young case, of course, which clarified matters as far as we were concerned, and there have been some administrative developments since then, but we don't anticipate needing to go to court again in that way.
So will you be issuing any guidelines to the practicing auditors in this respect, and what is your timetable?
There are discussions that are ongoing with the relevant professional bodies, and updates will be issued as and when those are ready. I'm afraid I can't be any more explicit at this point in time.
Okay.
單仲偕議員。
Mr. Sin Chung Kai, let us come back to reality. We understand that the SFC mainly watches over the stock market, but we have a lot of listed companies in Hong Kong. A lot of them have to do with mainland connections. Some Russian companies are listed in Hong Kong, but mainly we have mainland companies listed in Hong Kong. And by way of exchange of information, I think basically we are talking about the CSRC of China. So my question for you is, what is your objective? Is it that you will enter into a bilateral agreement with the CSRC, and what will be the scope of that agreement? My colleague asked whether there will be an appeal mechanism. I think an appeal mechanism is an important matter, because that would mean that the investigated corporation should have some right as to know what kind of information will be exchanged. I am also worried about reciprocity. I think the supervisory assistance will be helpful to Hong Kong investors in the end, because now we have the Shanghai-Hong Kong Connect, and Hong Kong people are now buying A shares. In the future, if there will be malpractice with regard to Hong Kong listed mainland shares, I think we should be able to get information about the mainland as well. So can we have some response, please? Mr. Shipton.
Thank you. I thank the honourable member for his follow-up questions. I do want to emphasise that the proposal before the panel and in relation to this proposed amendment is in relation to licensed corporations which are supervised by the Commission and also supervised by an overseas regulator. The scope of these proposed amendments do not cover directly listed companies. That is covered by different protocols and different procedures. The question in and around the appeal mechanisms, which a number of honourable members have mentioned today, I would emphasise a couple of points. Firstly, we do have right now mechanisms and provisions under Section 378 and other sections of the Securities and Futures Ordinance that enable us to exchange information on a supervisory basis and an enforcement cooperation basis. This is an existing and well-established path which is governed by the Ordinance. There is not currently an appeal mechanism for those other channels of exchanging information. Because this proposed amendment in relation to information requests from overseas regulators is, in our view, a narrow and very incremental suggestion, it would not on its face appear to require an appeal mechanism, given that an appeal mechanism does not exist under the current legislation and does not exist in relation to other jurisdictions with whom we have had discussions around exchange of supervisory information and other information.
Thank you, Mr. Christopher Chang. Thank you, Chairman. Actually, Mr. Shipton and I met many times, and I brought many groups to reflect the views of our industry. Mr. Shipton did not mention my name, and I'm a little disappointed. Maybe he's too busy and he doesn't remember my name. I'd like to talk about the protection of information. In fact, in our industry, many people have complained about this. They say, I go to a bank and I want to open an account, but I failed to do so. And then you have to pursue it many times, and then you know there is a case between you and the SFC. And that affects people, you know, when they go to a bank hoping to open an account. Now, this one here may not relate to SMEs, but only international companies. If there is sufficient confidentiality, then people will be protected, or else people cannot really conduct their business in a regular manner, and this may affect our status as an international center. I hope you will do more about the confidentiality of information and penalize anyone who leaks information. Thank you. Who will answer the question? Mr. Shipton?
I thank the honourable member, Mr. Chung, for his follow-up question, and I have always welcomed his meetings and references on a range of different issues, and I look forward to many more. The honourable member raises a very important issue, which is protection of information. We are proposing in relation to this particular amendment a number of safeguards in relation to the protection of information, because we are acutely aware that it touches upon corporations and potentially upon individuals. And those undertakings, we believe, will be sufficient in this regard to allay the concerns that the honourable member most, I think, justifiably raises.
Mr. Andrew Lam. Thank you, Chairman. When Mr. Shipton answered Mr. Sin Chung Kai, he said that the SFC already has the powers to do these things. Now, if you already have the powers, then you won't need this amendment. But now you propose this amendment, and of course, we scrutinize it using our thinking and consideration for the present times. Under the arrangements for tax information exchange, we also scrutinized it, and then there is an appeal mechanism. If you do not provide an appeal mechanism, then you have to watch carefully and count your votes. Today, if you want to propose an amendment, then we will scrutinize it using or applying our thinking for present times. You cannot say, or we cannot say that you should not propose any amendments. We can only say we would scrutinize your amendments applying our thinking and knowledge and consideration of present times. And we, the members here, are very familiar with the situation.
So if you want to move amendments, you must take on board views expressed by members, or else you can just present the bill and the result can only be one thing that we all know. If you want more powers, you need to move amendments, and we'll have to consider all factors. We won't just be confined to the amendments or the wording of the amendments. We'll look at how things are done internationally and other similar arrangements or protocols for information exchange. There are other laws on similar exchange, so we will be referring to those as well. I hope the government and the SFC would consider this rather unanimous request of members that we should ensure secrecy and there should be an appeal mechanism. Otherwise, this may be a futile exercise. Thank you, Mr. Leung. Well, I have already promised to refer to the appeal mechanism in respect of tax information exchange, and also we'll also look at the experience of rendering assistance to overseas regulators in this regard. Mr. James Tin. Well, I didn't want to speak at first. Maybe the government is confident that there are sufficient votes, and they will just proceed. But I think, having heard Mr. Andrew Leung, you have to make sure that you do have the support you need. Any response? Ms. Ho? I've heard the points taken. All right. The plan is to submit the amendments to this council in the middle of this year. Do you have anything to say about the timetable, members? If not, then I'll wrap up this item. Thank you all for your attendance.
但係咪 relevant 啊？其實係啊，咁我今次要叫啲人翻嚟投票喎，可唔可以記名投票得真？係咪完咗呢個先至咩？定係有好多做法，有啲委員會咧就會係即係提醒咗，咁然後咧就未必會需要辯論，因為你一個 discussion 嗰度可能都已經 touch 晒咗呢個咧，咁你可能會俾一個 chance 係我哋噏佢個 proposal， 咁就可以即刻投。咁但係而家係咪我哋做晒其他嘢先做呢個嘛？係嘛？係啊，即係等我哋講完嘢先講。好嘅。我都要讀呢個出嚟啦，係嘛？即係咪呢個叫臨時動議啊？係嘛？係啦係啦。OK。
我引咗先啦，好啊，好啊，好啊，好啊，好啊。好，嗱，而家我哋咧係首先歡迎咧係
Members, let us welcome the representatives from the administration and the Financial Services Development Council. Mrs. Laura Cha will be giving us a PowerPoint presentation. I hope it can be done in 10 minutes. Thank you, Mr. Chairman. We are here to report to members the work of the Financial Services Development Council in the last year and also looking ahead the plan for this year. We have already distributed the information paper to members, so I won't be going over the same points again. I would like to start with slide number 9 of the presentation. This is in a table to show you the 7 reports that we have released since 2014. Altogether, we have published 13 reports. In the coming 4 to 6 weeks, another 2 will be published. You see, this is a table that looks like a house. The first report that we publish is an overview of our financial markets and our systems. If we regard our financial sector and our financial market as a house, we want to make sure that we are a preeminent center in Asia. We have 5 different working groups. And they are all the important subsectors of our financial market and our systems and our infrastructure. And to start with, we want to enhance our competitiveness. We want to strengthen our core competencies and also to make the best use of available opportunities, and including opportunities presented by the mainland. At the bottom, you have 3 blocks which look into manpower, market development, and financial stability, and the right balance to be achieved. And lastly, we want to do something to promote Hong Kong overseas as a financial center. We are now facing very stiff competition internationally, and we would like to enhance our promotional efforts for Hong Kong. As for the component under Roman number 7, this is the foundation, and that is the support from government, industry, and community should be the cornerstone and foundation of our work. Without support from all sides, the Council will not be able to achieve our vision for Hong Kong. We published 7 reports last year. Maybe I should roughly talk about some of those. We have 1 report on the CEPA. CEPA has been with us for many years in terms of financial services. We have made certain proposals to the government, and we have proposed the adoption of negative list concept for free trade areas on the mainland. We also want to make it easier for entry into these the securities and financial markets of the mainland. We also want to ensure mutual recognition of funds and also to offer concessions for companies to set up investment joint ventures in the mainland. The second report is on the development of Hong Kong as an offshore renminbi-denominated reinsurance center. We emphasize the importance of Hong Kong for the mainland insurance market. And in this report published in 2014, our focus is on the offshore renminbi reinsurance market. We make certain proposals. That's the result of close cooperation with the insurance sector. And next, another report is on positioning Hong Kong as an international IPO center of choice. We conducted a comprehensive review. The focus in Hong Kong at that time was on the categorization of different shareholdings and whether all shares should have equal rights. Because the Hong Kong X was conducting a review at the time, we did not look into this in great detail. Apart from the issue of a same right for all votes or all shares, we did look into the IPO market. We want to make sure that corporations all over the world would regard Hong Kong as an IPO center of choice. And then there's another report. It's slide number 14, pilot scheme for training courses, developing Hong Kong's human capital in financial services. Financial services is part of the service industry. Service industry is an industry powered by manpower, human capital, and therefore training our manpower is a hallmark of a quality financial center. We conducted a survey, and some 30 corporations and 90 practitioners were covered in the survey. We understand in certain fields we do have a lack of a shortage of manpower, especially for backdoor or backstage operations in the financial services sector. We want whether prepare new graduates for entry into the industry. In 2015, we are going to look further into manpower training and human capital. And turning to slide number 15, we have a technical report. It's about disclosure of interest regime. The industry is of the view that the disclosure of interest regime is complicated and compliance is not easy, and very often people may inadvertently breach relevant disclosure rules. The government has proposed certain refinements and improvements to the SFC, and in this regard, we have been maintaining close cooperation, close liaison with the SFC. And lastly, I want to talk about promotional activities by the Financial Services Development Council. The industry has been saying that we are not doing enough in promoting Hong Kong as a financial center. Not that we have done not done anything, but mainly the agencies involved are the TDC, and when our senior government officials pay visits to overseas countries, they will also do some promotion. But it's just that we need to do more, and this year we were going to deepen collaboration with other stakeholders. In this year's Asia Financial Forum, which is an event co-sponsored by Hong Kong, when overseas participants came to participate in this flagship event of the Council, there was a breakfast event that we sponsored. And that's the only occasion in the two-day conference for an introduction to Hong Kong financial services, which was warmly received. for this year, for last year's work, I won't go into further details. Let's now turn to slide 25, work plan for 2015-2016. In the May, we are going to cover 3 areas. We want to explore opportunities. We want to look at the tax environment. There are certain uncertainties and ambiguities that may stand in the way of further development of the financial services, and we would going to cover this as a main area for further study, and we will be presenting constructive proposals to the government. As for the assistance given to mainland corporations to go out, and we want to assist mainland enterprises going global, and in the process we are going to have a lot of opportunities. How best can we seize those opportunities? Well, we are going to publish a report on what Hong Kong can do in this regard. And for other topics such as maintenance reform and development, offshore renminbi business, free trade zones in Guangdong, and the 13th five-year plan, and the latest topic is the AIIB, Asia Infrastructure Investment Bank, and what Hong Kong can do for AIIB. And another topic is asset management business and how it can be further developed in Hong Kong.
As for market development, I said that we would continue to do what we did last year. Maybe we're just going to do more. Last year, because of time allocation, we did not do as much as we had wanted. But in 2015-16, we like to do more by way of promotion. Every time we do it, we partner with the Hong Kong TDC because we do not have the resources to do it alone. Last but not least, talent. As we said, we would increase the understanding of graduates vis-a-vis different posts in the sector. And we are going to have the second Career Day held in November 2015. We'll also have career talks at universities by practitioners. Thank you, Chairman. I'll pause here. Thank you very much, Mrs. Cha. Mr. Kenneth Leung has just given us a motion. I'd like to read it out, that this panel would like to call the Financial Services Development Council a different Chinese name to give better indication of its functions, and the English name of the council should remain the same. This is for your information, and after we have dealt with the item, we will process this provisional motion to be moved by Mr. Kenneth Leung. As you know, last year, Mr. Leung moved the same motion. It was voted down. We are going to process it again after the discussion today. Now 10 members who would like to ask questions. Kenneth Wong Kwok-hing, Kenneth Leung, Mrs. Regina Ip, Christopher Chang, and 4 or 5 members more. 4 minutes each. I will be strict with the time because we have a pressing timetable. With Mr. Dennis Kwok, I'd like to refer to page 6 of the PowerPoint. You said that the arrangement will be reviewed this year, and that has to do with resources and manpower. What is your present thinking? Is it that you have a bigger work scope? And as Mr. Kenneth Leung's motion mentions, should you be called a development council in a way? Shouldn't you become an advisory committee? Is it that you are looking at your structure and work scope? Well, thank you. You talk about review of our resources within the year. It is because when we were set up, the FS said there will be a funding cycle of 3 years, and there should be a review after the first 3 years. In other words, starting from 2016, we should review our resources. Maybe I should defer to Mr. Andrew Wong to answer the question. P.S. When the FSDC was set up, we promised that there will be a review after 3 years. We need to do it this year. We are saying there will be a review, but it doesn't mean necessarily that there will be big changes. We'll have to take stock of the work of the FSDC and how it is expected to change, if in any way, in the coming few years. And also what resources were used in the past 3 years. We could see that a big part of the resources was spent on promotion of Hong Kong as an international financial center. And we are not talking about a big amount. Anyway, there will be a review this year to see we need to introduce any changes to the operation of the council. Do you have a plan to turn it into a committee? Do you think if it is turned into an advisory committee? Sorry, I did not hear you clearly. I mean a statutory body. For me, we think the present format has served us well in the past 2 years. You can see our workload and our work results. We depend very heavily on council members and committee members who are very dedicated. Well, I'll come back to this point later. If it is proposed that the FSDC should become a statutory body, well, I can't see how the format will necessarily change. And I think you need to have a time frame for setting up any statutory bodies. That is not our intention now. I haven't thought about changing the format. Members would like to do their best so that we get actual results. Mr. Wong Kwok-hing. Thank you, Chairman. I'd like to thank Mrs. Laura Cha for coming to the Council to introduce to us the work of the FSDC. I think what is most important is that the FSDC can do actual work and come up with results. I can see that you have really done a lot in the past 2 years. Given the very difficult external and internal situations for Hong Kong, particularly when we have a very trying political environment, you have been able to withstand pressure and be able to work so well. I compliment your good work. I think what matters is the substance. If there is no substance, it doesn't matter if you call it a beautiful name. Therefore, I'm not going to support the motion by Mr. Kenneth Leung. I'm not going to support it. I'd like to ask Mrs. Cha a question. I don't know whether you are aware of this, that all these years we have seen so-called OTC scam with regard to London gold. I have received many complaints, and like 8 to 10 such complaints, and a huge amount is involved. And I'm talking about OTC transactions in London gold and silver. And I have talked to the gold and silver market, and I know that they also think it is necessary to make laws. Unfortunately, the administration is unwilling so far. The gold and silver trading market runs training courses and it issues certificates, but it is not a government body. The certificates only serve to certify that their members have this qualification, but that is not necessarily legally recognized. So FSDC, can you do some research into the issue? We have seen such deception cases, and they have a negative impact on Hong Kong's reputation as an international financial center. And not only locals are victimized, even mainlanders are victimized now. Some of them come from Harbin. Can please Mrs. Cha respond to the question? Thank you, Mr. Wong, for recognizing our work. Given the present environment, really it is the members who are very dedicated, which has allowed us to achieve so much. As for London Gold, I think it has plagued Hong Kong investors for some time. But the FSDC is only tasked to research into policies. We are not an enforcement body. I believe it's up to the enforcement bodies to work against deception cases. We can look at the overall situation and come up with proposals, but we need to listen to people from the industry. Maybe I can ask Mr. Haywood Chung to speak on the issue. Thank you for your positive stance. I can write to you to supplement the information for your reference. Mr. Kenneth Leung, I will come to my motion later. I need to declare interest first. Mark Shipman, a member of the Council, is my colleague at work. In 2014, many research reports have been issued by the Council, and I also recognize their good work. Mrs. Laura Cha, can you find some time to do something? It is not that all our colleagues may be very interested in the fine details of your reports, but maybe not here at LegCo, but can you find some time to brief LegCo members on the reports you have written, the most important findings in those reports, so that we know the latest developments in our financial sector and what proposals you have made to the government? Can you consider this? Number two, about your work for the next year. I understand that you should be looking at other things as well. For example, green banking and green financing. Is it that you have not included everything in the PowerPoint? Mrs. Cha? Thank you, Mr. Leung. We are most happy to introduce our work reports to you. In fact, I also hold informal briefings and sandwich lunches, and you have been there. I can arrange more. I can introduce reports that have been issued, and those who are interested are always welcome. As for our work plan for 2015-16, and is it that not everything is included in the PowerPoint? Indeed, yes, but those ideas are not mature yet. We don't want to give false hope to the community or members that we are certainly going to do something. Green finance is indeed one initiative. Why are we interested in green finance? Because we know that in London and other big international finance centers are involved in that. It is big business, but amongst the members at the Council, we have no members who have a sufficient understanding of the issue. And we have now succeeded in convincing one or two members who would follow up the issue, and we are going to co-opt other people who are knowledgeable in this. We hope to write a report on green finance, and within that very big scope of green finance, we would comment whether there is any room for development for Hong Kong. Chairman, I mention this because I'm a member of the Environment Affairs panel, and secondly, you need to look at the overall situation. I mean the financial situation in Hong Kong compared to our functions or future functions of AIIB. I'm sure green finance is very much connected with it. So either you co-op members or find external resources. I hope the FSDC will expedite your research into green banking and green finance. And I myself can certainly help to provide resources and manpower. I am very willing and happy to write that research report with you. Thank you. Thank you very much, Mr. Leung, for your support. We will contact you later. Mr. James Tian. Chairman, financial development is certainly the biggest driving engine for Hong Kong, and many people also can benefit a lot from the industries. As you know, when the stock market is buoyant, even restaurants have a much better business. And maybe the property market will benefit later. But coming to the councils, we have the TDC, we have the Tourism Commission. They have actual powers. But as Mrs. Cha said, you are only a policy research body. Mr. Zhang is not here, but indeed, you give people the impression that you are just a research body. We all hope that you will indeed become a statutory body so that you can have all the reasons and the rationale to put into practice what you are proposing.
Looking ahead, I think Europe is not going to do well in the coming few years. Southeast Asia too. Our future lies in the mainland. You talk about the same share, same right principle. But what we are doing will be very much related to the mainland. You look at what happened last week. I don't know what role the Council played in the events that took place last week. They changed the rules only a little bit and see what happened. Well, it's just that if they allowed a small portion of their funds to be injected into Hong Kong, it's a deluge in Hong Kong. If you look at overseas regulatory regime, and so that Hong Kong can move up to the so-called the top as a preeminent financial center, can we just rely on the opportunities presented by the mainland? Or should we be doing what the Southeast Asia and other countries are doing, and that is to say we should use English? And I'm not just talking about rules related to securities, but law generally. And also, I want to say something about promotion. Now you just latch on to the TDC activities for overseas promotion. And very often you also involve mainland practitioners, and the promotion is also about the mainland market. It seems that you have become a sort of agent. So can you look into promotion to see how it can be improved? Mr. Tin, I think you are referring to the influx of funds from the mainland last week. The Council is not a part of the government, and we are not an enforcement agency. There are the regulators which are doing a good job. We'll be looking at the development and the capacity, the breadth and the width of our markets. And when it comes to the width and the breadth of our market, we need to build our capacity. That's about our infrastructure and how deals are managed here. That's why we need to increase manpower for midstream or backstage operations. That's what we are going to do in terms of training. As for our status as a financial center, we cannot just rely on mainland. We have many resources coming from the mainland. We need to attract talents from the mainland. But as an international financial center all along, in the past 3 or 4 decades, all along we have remained open. We have been an open market. people in the US or in Europe will be attracted to Hong Kong if they do see a future here. We can attract international talent to Hong Kong, not just in the security sector. We have also got mutual funds and private equities, and we have been able to attract talents in those fields. Mrs. Cha, time is limited. Perhaps you can take it up further with the member later. Mr. Sin Chung Kai. Well, the FSDC has published some reports, and the reports will have to be implemented through the government or other agencies. I just want to make one comment on your work plan. We have seen the Shanghai Hong Kong Stock Connect, and the mainland market is gradually opening up. I've asked questions about investment safeguards. With an open, more open market, we need more safeguards. But it seems that in your work plan for the future, your focus is more on development. Of course, it's in the name of the council, but you need to strike a balance, and that is you need to protect the investors. And you know that we have witnessed some deception cases lately, and very soon the Shenzhen Hong Kong Stock Connect will be implemented. And so mainland investors can, Hong Kong investors can invest in mainland stocks through the Shanghai Hong Kong Stock Connect or Shenzhen Hong Kong Stock Connect. So would you be willing to look into safeguards for investors in your future work plan? Thank you for your question. Under the existing work plan, we have not covered investor protection, whether it's related to the mainland or other investments. As the member has put it, our focus is on development. The government has already set up a dedicated organization on investor education. I think it will be the main function to educate investors. As regards Shanghai Hong Kong Stock Connect or Shenzhen Hong Kong Stock Connect, we would like to explain clearly to investors through investor education programs. If you invest in U.S. securities, and you must understand that those stocks are regulated by the U.S. Likewise, Shenzhen stocks or Shanghai stocks are subject to local regulation. Mr. Wong Kwok-hing, the CPG is going to announce the establishment of Fujian and Tianjin free trade areas. And also there will be the Guangdong free trade area. Sorry, excuse me? I think that's very loud. Has the FSDC looked into the implications, the opportunities presented by Guangdong free trade area? Are we going to expect more challenges or more opportunities? And how should our financial services be prepared to take advantage of the latest development in Shanghai Hong Kong Stock Connect, Shenzhen Hong Kong Stock Connect, AIB, or the Maritime Sea Route Program and the 21st Century Sea Route Program? Mrs. Cha, of course, the Guangdong FTA is going to be very important for Hong Kong. Well, it's too early to tell whether there will be more challenges or opportunities. We'll pay close attention to the development. 2 weeks ago, together with the committee, on mainland opportunities, we visited the Shenzhen Stock Exchange. what the FSDC can do is to gain a deeper understanding of what are the likely implications for Hong Kong. This is going to be a topic for the Council. You are going to set up a steering group to conduct studies on how to make Hong Kong into a technical hub for financial services. What are our advantages in this regard, and what are the challenges? Well, that's why we need to have a steering group on this topic, because at present we cannot really tell that whether in the field of financial technology what Hong Kong can or cannot do. My understanding is that in respect of electronic transaction, we are quite advanced. Whether we're talking about the banking sector or the securities industry, we have been promoting a paperless system for years. But to take matters further forward, we need to conduct a study to see what technology can be utilized to enable us to move into a new level or new scope of business. But at present, I don't have ready answers. Mrs. Regina Yip. Thank you, Chairman. First of all, I want to thank Mrs. Chia for the contributing to the development of the industry so tirelessly. There's something not mentioned in the presentation, and that is Islamic bonds. The government has amended the law to enable the development of Islamic bonds in Hong Kong. We know that the global center is London. In Asia is Kuala Lumpur. And Singapore has a head start over us because they have a big population of Muslims. Can we see some opportunities in the promotion of the Silk Road programs by the mainland? And also for manpower and talents, can we get some elaborations on what we need? I know local graduates are finding it more and more difficult to get recruited for top positions in international corporations. And because mainland graduates enjoy certain advantages such as Putonghua. I thank Mrs. Yip for her appreciation of the work of FSDC, and I also thank her for her unfailing support to the Council. We have been promoting Islamic finance, Islamic bonds for some years now. And yes, she's correct that this is not in our work plan. We have been doing promotion, and we do enjoy certain competitive edge. Dubai would like to be an Islamic finance center in Asia. Kuala Lumpur is doing well because they have a big Muslim population. When we launched this, we wanted to make our market more diversified by offering more products. And then how successful can that be? Well, that would depend on the promotion and further efforts. On the question of human resources, top-end human resources, compared with overseas graduates and mainland graduates, local graduates suffer certain disadvantages. First, their English competency is regarded as inadequate. This is a shock to us. We thought maybe they are not as good in Putonghua, but now it's said that English is also not good. And many graduates are not quite knowledgeable about what's happening around the world. Well, you know, when you want to apply for a job, the interviewer would ask you about your views, your take on global events, and very often the graduates cannot offer good answers. And many graduates, local graduates, think that if they want to work in the financial services sector, they have to work in an investment bank, or do something in the front line. But there are chief bid officers who are also board members of the big corporations, and we should try to introduce to local graduates the idea and the importance of backstage operations and mid-stage operations as well. We would like to do some promotion of that nature. Mr. Christopher Chung, the Council has pointed out that there is a lack of qualified professionals in the financial services. I support further studies be conducted and human capital be nurtured. But I do have a different idea about the proposal to introduce mainland professionals. Financial services are the most important sector in Hong Kong. Over the decades, many professionals have been trained in Hong Kong. I think future graduates will be more than willing to join the financial services because of the opportunities there.
I'd like to ask whether the FSDC can consider, first of all, considering engaging locals as financial professionals, and then regard mainland professionals as a secondary support. I think that would be good for Hong Kong. I understand the FSDC has done a lot in the past 2 years, and you have come up with many constructive ideas. So my question for you is, apart from the career days that you hold and also career talks that you give, what about training Hong Kong talents? What more can be done? Will you draw up a plan with the Education Bureau to train up financial professionals? What is more important? Will you set up a task force to help in-service practitioners to transform so they can welcome the IT age? Mrs. Cha. Thank you, Mr. Christopher Chung. In terms of professionals and talents, what I said already target local graduates. It is not up to the Council to say we want to import or introduce overseas talents. We are a free economic entity, and we have always welcomed professionals or otherwise from outside. In terms of the financial sector, you can see that we have a very big international element, and I also include mainland professionals here. Therefore, it is important for us to train up local students and local practitioners. This is what we are aiming at. You talk about making a plan with the Education Bureau, but we are only an advisory body. We have no ability to formulate or help produce any teaching material. What we can do, however, is whenever courses are proposed by training institutes, we are quite happy to review the courses for them from the angle of a professional or practitioner in the sector. So they can come to us for comments. And as for cooperation with the Education Bureau, I don't think we have the capacity to do it. Maybe Mr. Andrew Wong can say something about the government. The FSDC issued a report earlier on, and members would remember that in the budget of the FS said that in terms of training up financial professionals, we will emphasize it, and that is why $100 million have been set aside in the budget for a 3-year pilot. It is going to be a pilot. We would concentrate on asset wealth management and insurance to start with. This is to respond to the recommendations made by the FSDC. Ms. Dari Lee? Chairman, first I'd like to thank the FSDC for their efforts, and under the able leadership of Mrs. Cha, the FSDC has written many reports, and I hope the government can review its support for the FSDC from time to time, because all the members are volunteers. They bring their knowledge, talent, and also time to the work of the council, and they also write their own reports. So I think the government should support them more and also put in place their recommendations. Like other colleagues, I'm also concerned about the lack of financial professionals in Hong Kong. Let us look at it from the angle of upward mobility for young people. Finances are a high-end industry. It is very attractive to young people, and it affords the opportunity for upward mobility for young people. But then, in the Hong Kong society, we see that we don't have enough professionals in the sector, and then young people are complaining about the lack of opportunities for upward mobility. So it seems there is a mismatch. As Mrs. Cha said, employers are saying that Hong Kong students may have certain characteristics which do not afford very good positions in the financial sector. And I can see that perhaps that's true. Maybe Hong Kong students cannot take up high-ranking positions in this high-end industry. This is from my own observation. I think the government and the FSDC should take a square look at the issue. But this issue has been with us for some time, and Mrs. Chow, you have written the report, and the government has come to know about it. So are you talking to universities so they can adjust their course materials in a suitable way? And are you telling university students that they need to upgrade themselves, that they need to undergo continuous self-improvement and enhancement so as to get opportunities for upward mobility? Thank you, Ms. Lee. First of all, thank you for recognizing our work. And I think you have made a very valid point. There are two aspects to talents and professionals. One, course materials in universities. We hope that when universities draw up their curricula, if they like to get our comments, we'll be very happy to give them very practical views. Secondly, with regard to training of young people, well, we organized a career day last year. It was hugely popular, so it will be repeated this year. There will be two aspects. Those who are already accomplished in the industry will tell their own stories. They maybe employers, they would tell young people what they expect young employees to do and what kind of special knowledge and skills they are looking for. And secondly, there will be a road show. In the latter half of April, we will cooperate with the 10 universities. They will be the organizers, but we provide the lecturers. And the lectures are not about a particular sector or segment of the financial sector, but we will tell students what kind of jobs there are in the sector, apart from investment banks, the insurance industry. We are also going to tell students what other jobs there are. We will introduce and explain things to them. And secondly, we will take turns to go to the 8 to 10 universities. The career officers very much welcome our initiative. I hope after the first kickoff in the latter half of April, we hope to be able to have 1 or 2 such opportunities to exchange with students, to introduce to them the job traits and what they need to equip themselves with if they want to enter the financial sector. Mr. Ng Liang Sing, like to join other colleagues in complimenting the work of the FSDC. They have worked with so much dedication on a voluntary basis. Financial development is very much linked to financial supervision. I do think that if the Council has mapped out its own pathway, it should be able to expound its functions. As members said, we like to take our financial services sector up another rung. I believe the development of our financial sector can generate more wealth for society, and I don't think anyone would question that. If I may go to page 8 of the presentation, the 3 key areas of work for 2014, collaborating with the sector, promotion, and nurturing human capital. All these are not easy. The government has now got for free the results of your hard work. Maybe the sector will benefit, but this should not be the same for the long term. Research results should be shared, but why is there no reward? I think that cannot last for too long. Promotion and publicity, you need a lot of money to do that. If no cost is incurred for promotion and publicity, I don't know how that can happen under a market economy. And nurturing human capital, again, we need money to do that. Perhaps we can do something with the Education Bureau vis-à-vis the qualifications framework. I think there can be cooperation between the FSDC and the Education Bureau in this aspect. I think the ITEX, that is the trade committees, are doing that under the QF. Now we have the TDC, we have the Tourism Commission. These are important entities for our pillar industries. They are helping with the mapping of development directions and also doing promotion. I think the FSDC, therefore, should be given a higher status as well as given more resources, or else I can't see how the present format can last longer. I don't need a reply now. I think the government should consider it. The LegCo should cooperate and the public should support, and the industries should play a synergy role. I want the government to come up with a medium and long-term cost effectiveness plan for the FSDC as soon as possible, so that benefits and wealth and jobs can be generated for the sector as well as Hong Kong. This is my proposal for your consideration. You are right on the dot. Mr. Chen Kam-lam. Chairman and Mrs. Cha, you have both worked very hard. I think in the past period, if you look at the stock market, the transaction volume would be regarded to be big if it is just 60 to 70 billion, but now it has risen to more than 100 billion per day. It seems this will stay at a high position for some time, but we lack talents in the field. With the Shanghai-Hong Kong Connect, there is more transaction volume and there will be more fund products in the future. I'm sure there is a keen demand for talents. Mr. Christopher Chung, of course, knows that there are many brokers in the field, but then we also need market analysts and market promoters. As we see it, among the 3 key areas proposed by the FSDC, I think they are not enough. You are only talking about career talks and courses, but that won't allow us to have all the professionals and talents we need. The university curricula just cannot take care of the needs of the market. I hope you will make even more proposals in this respect in the future. You can talk to the main universities how their curricula can be adjusted to suit market needs. And you should have a gradated kind of training course so you can turn out talents the market needs. We do not only need brokers who are just like salespersons in a department store. Those may not be jobs to the liking of graduates. I hope we can do something here. And also, with regard to a proposal made by you just now about the market.
咁其實而家我哋 T+2 係嘛 T+2 定 T+3？
You have to consider the current cycle is T+2, right? Please look into the possibility of reducing it to T+1, so to shorten the cycle and increase the flexibility. A little relaxation here may help the market a lot. And Mr. Christopher Chung has commented on the import of talents. This is important. We should relax the policy. We should allow the professionals and talents to be imported. That would yield a quicker result than training our own people in the universities. A short response, please. You've just got 10 or seconds left. I thank Mr. Chan for his constructive ideas. We are working on several issues already, but for the long-term issues, we need to ask the policy bureaus to do more. We can make proposals, but we are not an executive arm. So with your support, and actually some of the proposals we make have been accepted by the government. All right, if there are no further comments or questions, let's now deal with the motion moved by Mr. Kenneth Leung. You have got the wording. First of all, I have to decide whether this is a related topic for the panel. So my ruling is that it's related. So let's deal with this. Any objection to my decision? Mr. Kenneth Leung, over to you to explain why you want to move this motion. I need 2 minutes. I need just one. Okay, 2 minutes is fine. Let's revert to some of the topics we have discussed. For example, talents for the financial services. Mrs. Cha, I think we should have a dialogue. It's not just a question of changing the training programs. If you talk about the trainee or the graduates, if you want to train up these people, they must gain the right perspective, the right expertise through on-the-job training. So apart from changing our training programs or courses, these people should be given more chances to work in financial firms. The day before yesterday, there was an article in New York Times. There's an article by Harvard professor Vide he's concerned about so many graduates trying to work in the financial sector or in banks. Let's return to this motion. This is the third time I moved this motion. The first time was in the year before last. The thinking has changed a bit. According to the chairman, you cannot do this, you cannot do that. The council members are working very hard. My colleague, Mr. Ma, has complained that they have to work for so long. They are using their own resources, their own time to work for the council. If your direction is to do things on a wider scale and you want to get a bigger structure established, then you must as well transform into a statutory body. Your council is different from the Tourism Commission or the TDC. So I would like to propose this change. Who would like to speak on the motion? Mr. Cham Kam Lam, 2 minutes. I don't think there's a need to change the name, since the council has already been named and we know the functions. The functions are very clear. There's no confusion. We have many advisory bodies or NGOs which are called GOG or council. I don't think we should get involved in complicated things. And the proposal is also changing the Chinese name, but not the English name. But if you want to call it a 委員會 in Chinese or committee in Chinese, you might as well change the English name to a FSD committee as well. Mr. Wong Kwok-hing, as I said earlier, I oppose to this motion moved by Mr. Kenneth Chang. Mr. Kenneth Leung. The council has been working well and has achieved good things. As I've said, the council members have contributed to the work of the council selflessly and tirelessly. And if you want to do it in a better way, if you want to expand your scope, I hope the Pandemocrats will not oppose to funding proposals from the council in due course. So with such assurance, you can come back to ask for more funding. So I think we should not change the name. Anything that the government or the council would like to say in response? First of all, I don't want to change the name. We have achieved something in the past 2 years which has been well recognized in the community. If we change the name here, people may think that we are not doing a good job, or there are certain other motives behind. Anything from you, Mr. Andrew Wong? But the same topic was discussed previously in the panel. The government's position is that there's nothing wrong about calling this a council. And as Mrs. Cha has said, the council has been in operation for 2 years. If we change the name now, it may cause confusion on the part of the general public. Mrs. Regina Yip, well, I'll draw the line here. You have 1 minute. I just want to offer quick remarks. I think it's beyond our power. If you don't like the name, you can say so, but I don't think this council has the power to seek a change in the name of the council. All right? Let's proceed to a vote. You want to call division? All right. Members, please don't have a discussion among yourselves. Mr. Zhang, please, let's proceed to the vote. For those in favor of this motion, please raise your hands. Do you want to sound the bell? Okay, let's sound the bell for 5 minutes.
好，請支。
All right, for those in favor of this motion, please raise your hands. Mr. Kenneth Leung. Those against, we are jotting down the names. Please read out the names. On behalf of the chairman, I'll read out the names who are in the member who are in support is Mr. Kenneth Leung. Those opposed, Mr. John Kamlan, Mr. Wong Kwok-hing, Mrs. Regina Yip, Mr. Wong Kwok-hing, Mr. Starry Lee, Mr. Christopher Chung. So 1 for, 7 against. So the motion is vetoed. Thank you. We have finished our agenda. Thank you.